if you reply and you don't give them exactly what you need, they could easily deny your application. And you might not even find out that it's denied for another 6 to 8 months. So in addition to losing 8 months where you could have had your green card already, you'll also have to repay the $1,760 government filing fee. Hey guys, welcome back to my channel. For those of you who are new, I'm Puyan Darian, an immigration attorney, and I focus my practice almost entirely on family-based immigration. Today we're going to be discussing 5 ways that your easy green card case could get denied by USCIS. One of the most common ways that I see easy cases get denied is by either not replying to the request for evidence, or if the request for evidence is specifically about the affidavit of support, not resubmitting an entirely new affidavit of support. So what will often happen right after you apply for the green card is USCIS will send you a request for evidence, and they will give you 87 days to respond. And the request for evidence, when it pertains to an affidavit of support, will just be a boilerplate 3-page long request for evidence. It'll say something like you haven't submitted enough evidence that your sponsor meets the financial guidelines. You need to show that they earn 125% of the federal poverty guidelines, and a whole bunch of stuff. And you might be thinking, but hey, I already submitted all of these documents. What do they actually need? And at that point, I would strongly recommend hiring an attorney to assist you with at least responding to the request for evidence, because if you reply and you don't give them exactly what you need, they could easily deny your application. And you might not even find out that it's denied for another 6 to 8 months. So in addition to losing 8 months where you could have had your green card already, you'll also have to repay the $1,760 government filing fee. What I typically do at this point is I will resubmit the entire, new fresh affidavit of support with new tax documents and evidence that your US citizen sponsor is in fact a US citizen, so a copy of their passport or certificate of naturalization. Another big mistake that I see people make when they are applying for a green card through a spouse is they don't submit enough evidence of their marriage. They just think, hey, we're clearly married. When we go to the interview, it'll be easy for the officer to see that we're married. I'm not worried about it. But that's actually a huge mistake for 2 reasons. First of all, if you don't submit enough documentary evidence of your relationship, and if you're wondering what I mean by that, you should check out all my other videos. I do a bunch specifically on what evidence to submit and to bring with you to your interview. The officer is going to be blind going into the interview, and it's going to be a much more hostile interview where they're questioning everything, and at the very least, you'll spend way more time in the interview. The other big reason to submit as much evidence as possible, especially if you're watching this video after December 2023, is USCIS might decide that you've submitted enough evidence and not even decide to interview you. While you're waiting for the interview notice, you'll just receive your green card in the mail, and you'll save yourself a whole bunch of headache and time. Another big mistake that some people make is they fail to bring the original documents to their green card interview. So when you're first applying for permanent residence, your green card, you're only submitting photocopies of all of your documents. Your birth certificates, your passports, your marriage certificate, if you've been married before, your divorce certificates. But when you go to the interview, you need to bring not only the original documents or certified copies. For example, if it's a divorce certificate, it needs to have a stamp on it saying it's a certified copy from the court. But if these are foreign language documents, you also need to bring translations of the documents. I also strongly recommend that the US citizen sponsor bring an updated tax return. And of course, if you haven't submitted your medical exam yet, or if your medical examination is more than 2 years old, you should bring an updated new medical exam, which you will unfortunately probably have to pay for. One of the biggest mistakes that I see people make at the interview is that they'll make stuff up because they think that they need to be able to answer every question. For example, if the immigration officer asks you, all right, if you're living at this address, tell me what the color of your front door is, Don't just answer that question if you're not sure what color your front door is. And you would be surprised at how many people blank out and don't remember what color their door is. Simple stuff like that is a ridiculous way to get your green card denied. If you don't remember, just say, I'm sorry, I'm nervous, I don't remember, or I don't understand the question, or I don't know. It's perfectly fine at the interview to just say you don't know. What I prefer is for you to say, I don't know because, and then offer a short explanation why. For example, if they ask you, how many brothers and sisters does your wife have? You could say, I don't know because she has like 8 brothers and sisters, and most of them don't live in the US, and I've only met one of them. And then tell the officer what the name of the one brother or sister is. Just tell them what you do know, and don't worry about telling them that you don't know. The final mistake that I see a lot of people make is applying for the green card when they aren't eligible. A clear example of this is if you've married someone who's a permanent resident and you're trying to get your permanent residence, but you are currently out of status. For example, you've entered as a tourist, your status expired after 6 months. Sometime thereafter, you marry a permanent resident and you apply for adjustment of status inside the United States. You are probably not eligible. In that case, the move would be for your permanent resident spouse to first become a citizen so that your unlawful presence in the US will not be considered against you. Otherwise, your green card application will eventually get denied. Another thing is if you've entered the US without status, if you've entered through the border and you just apply for a green card after marrying, you're probably not eligible unless you meet one of the specific exceptions to the inspection requirement. There's a general requirement that you be inspected before you can marry and apply for adjustment of status in the US. I see this all the time during consultations, and I have to give people the unfortunate news that you're not eligible to apply for adjustment of status right now. There might be other options, but you might eventually need to go back to your home country for a consulate interview before you're permitted to re-enter as a permanent resident. This is a highly fact-specific determination. You really would need to speak to an immigration attorney if you entered the US without status. And if you have these types of questions, I would be happy to talk to you about it. Alright guys, that brings us to the end of today's video, 5 common mistakes that people make. If you have any specific questions, you can put them in the comments below. I do try my best to answer every question for at least 1 week after a video has posted. And if you're new to my channel, be sure to subscribe. I put out a new video on a weekly basis, and I'll see you guys next week for another video.